When I became an attorney 36 years or so ago, law was in and of itself a male-dominated field, and litigation within the practice of law was the worst when it came to the participation of women. Other than handling adoptions and divorces or working for the government, there were few women who were actively engaged in litigating civil cases. I started working in a male-dominated industry, and that just doubled the problem, because even when negotiating on behalf of my client, I would frequently be marginalized, not only by the person with whom I was negotiating, but even by my client. In those days, pretrials were held in the courthouse, and at pretrial conferences, a claim representative or an adjuster would always come with, since that was the person who had the authority. I was essentially invisible. Judges would talk to the claims person with authority. They would never really ask any questions about the litigation or the likelihood of trial or my views about the success of a trial. Those situations where judges only want to talk to the attorneys and have the clients wait outside never happened to me when I first started practicing law, because the judges never wanted to talk to a woman, especially a young woman, about whether or not a case could be settled. The government attorneys were different because they were used to dealing with women professionals, and it was much easier to deal with individuals from regulatory agencies, because they were frequently women and they were frequently dealing with women. It was hard to decide what to do. Should you act like a man? Should you drink like a man? Should you swear like a man? But none of those things were particularly ideal in a corporate environment, and so after a fairly short period of time, I left to go in private practice because I didn't really enjoy being a square peg in a round hole. In private practice, what I discovered is that while my clients were supportive and believed in me, because all of my female qualities allowed me to bond with them on an emotional level about their litigation, judges were still not particularly supportive of me, and basically continued to treat me and other women like we were bubbleheads who didn't understand what we were doing. And so then it became clear that we, all of us, but me in particular, on my own as a woman, had to work twice as hard to prove that I was equal. In fact, I had to be better just to be equal. I had to be smarter just to be equal. I had to work harder just to be equal. Fortunately, when negotiations failed, cases had to be tried, and the result of it is that I think, had I been a man, or had a man had the cases that I had, my cases might have settled, but they didn't settle because I couldn't find a way to communicate with my opponents or the court to convince them of the rightness of my client's position. And so the result of it is that I tried more cases, and that ended up actually being a good thing too, because I learned how to try cases, and I knew how to relate to juries, and once I had proven that I could not only talk the talk, but I could walk the walk, it was no longer a problem getting credibility in front of judges or opposing lawyers, because I had tried cases, and they knew that when I said that I wouldn't be afraid to put a case on in front of a jury, I wasn't kidding. And the truth of the matter is that once your opponent knows that you aren't afraid to try cases and that you know how to try cases, it really doesn't matter what your gender is, because they'll negotiate with you on a fair basis simply because they don't want to try the case that you're willing to try.